Go ahead. Welcome to those coming in. We're just waiting on the full number of attendees to fill up. I'll say it every couple hundred people or so. Welcome to everybody coming in. We're just waiting on the full attendee list to populate here. All right. In the interest of time, I'm going to treat it a little bit more like popcorn. Looks like the rate of joining is slowing, so let's go ahead and kick things off. My name is Alex Howe. I'm a UniServ organizer in the Northern region, and I'm going to be serving as a moderator for this webinar. We're also going to have Pam Dilbeck and Chad Hunter, who you should be able to see on your screen, who are going to help moderate the questions that are coming in. So information should be going into the chat relatively soon about how each of you can use the Q&A system, and that's going to be the only way that you can send information to us on this webinar format. So keep an eye out. It's just in the chat right now on how to use that Q&A. Last little bit of housekeeping is that we will be recording this session. So if you have to jump off early, or if you have any colleagues or anything like that who are not able to catch it right now, there will be a recording posted at a later date. All right, so with that in mind, I'm gonna turn it over to Keith Gamble. Keith is a middle school music and drama teacher. He's been one for more than 30 years, and he is the ISTA president. So go ahead and kick us off, Keith.
Good morning, thank you, Alex. Good morning, everyone. Happy to welcome you and to thank all of our panelists who have been so gracious to share their expertise today in this platform, because educator rights and in our schools during this reopening is extremely important. Educator rights is something that is important always, but certainly during these times of the pandemic, it calls into question other aspects of our work life. And so that is the focus of today's session. I hope you find it to be very helpful. Again, thank you all for those that are participating and to all of our panelists. I hope you have a great webinar. Thank you, Alex.
Absolutely, and I'm noticing a note about echo in the chat. I'm hoping that the echo has gone away now that all of the panelists are on mute. That may have been the issue, I'm not sure. So just let us know in the Q&A if the echo continues. So next up, we're going to hear from Rick Scalf, who is a UniServ organizer in the southern part of the state. Rick, go ahead.
Thank you very much. Let me share my screen here with you all. All right. So we wanted to discuss today the fact that there are fundamentally two types of problems that you'll be addressing. Problems that are already addressed in our contracts or in law, and problems that are not addressed in the contracts or in which the law may not work in our favor. So the Columbus Educators Association offers a perfect example because they've recently worked through both types of challenges. And in fact, this spring had to do so more or less simultaneously. One issue concerned their working hours. and an administration that insisted on requiring them to work beyond those hours without pay. At the same time as they were addressing that issue, they had the opportunity to pursue a referendum which was designed to improve the quality of life for the educators in that and support staff in that district. Unfortunately, they faced a community that had failed to support those efforts multiple times in the past. Now, for the working hours issue, the contract already provided a solution, so a legal path to victory existed. And after a series of public meetings with their members, which were designed to keep them engaged along the way, they were able to bring the legal expertise of the association to bear and secure a victory on that topic through the process of mediation. The referendum, however, called for creative, collective public action. So, how did the Columbus Educators Association win that referendum? First, they surveyed their members to figure out if it was important to them, and it was. 95% of the local association supported endorsing that effort. But it wasn't enough to know how broad the support was. They needed to know how deeply their members felt about it. So second, they found out a way to determine just how strongly people felt about it. Through a process of direct one-to-one interviews with their members, they determined how much people cared and this was key, what concrete steps they were willing to take to pursue the effort and to secure the victory. Third, they made and carried out a plan to engage their community and ultimately deliver the votes. And they won. In fact, they won 61% to 39%. And they did it, remember, in a community that on 3 prior occasions had failed to pass referenda. So as we discuss the topic of reopening, take a moment and be honest with yourself. Which of those 2 situations is most like the situation that you find yourself in right now? Because in a few minutes, you're going to hear about the incredible efforts that ISTA has dedicated on the legal front towards the issue of reopening. But you're also going to hear something that's very important. The law often doesn't offer a solution to your problems. In fact, in some cases, it may be specifically designed to hinder you from achieving the results that you're seeking. So in that case, the only option is a campaign of public pressure. So ask yourself, is the law going to be your solution, or are you and your coworkers the solution? The same simple model that worked in Columbus can also work for you in your local. Talk to your members and learn what they want, determine how committed they are to doing it and what they're willing to do to achieve the victory, and then plan and carry out collective action that accomplishes those goals. Now, I already know that some concerns crop up along the way. And in fact, I spoke with my colleague, Alex, who's moderating us today, and asked him if he would jump in and sort of give some voice to some of the concerns that he's heard as we've had conversations with some of the locals that we've worked with on topics like this already. Alex, what have you been hearing?
So one of the first questions that keeps cropping up, I would say, is, okay, so a survey, what if the results are split?
Yeah, that's a fair question. But my first reaction is, what do you mean by split? 80-20 isn't split, certainly. 70-30 really isn't either. And even 60-40 isn't that split if the strongest feelings are on one side. But a lot of times, even in a situation where the issue may have a definite preference like that amongst your membership, it can feel like a 50-50 split and evenly divided local. And frequently that's because the split exists amongst the voices that we're hearing. So that's why it's important that we find a way to reach out, create some feedback, and that feedback is not only broadly based amongst our membership, but is also recent.
All right, so another one that I'm hearing a lot is something along the following. We've been developing this reopening plan with the corporation for ages, and we've already given people a chance to talk throughout that entire process.
Sure, but I think it's fair to say that people are a little bit overloaded right now. It's also not uncommon for people not to really engage on an issue until it's right in front of their faces and it's starting to affect them. And we've seen a lot of that. And also, I think that people's thoughts have a tendency to evolve over time as more and more information becomes available to them. And it's important that we as organizers and as leaders in our local respect that process. In fact, I've worked with a number of leaders here in the past few weeks who have done recent surveys of their members and have been really shocked by the speed with which sentiment has shifted in their local. That we've seen some surveys where, for example, a local was 60% in favor of pursuing the particular elements of a reentry plan, only to come back 3 weeks later and find them 70 to 80% opposed. These things are moving quickly, and that's why it's important that we continue to maintain communication with our members.
All right, so looking at what I've heard, I want to ask two more of you, Rick.
Okay.
One of them is still going to focus on the survey, and the question is, the survey only represents a limited portion of our membership.
Sure, but that's true of any survey. And certainly we want to make sure that we accept, not accept, but survey as many folks as possible. But at a certain point, it's also worth considering that the folks who responded are the folks who are the most engaged on the issue and were engaged enough to take the time to complete the thing. And if the issue is hot enough, I think you'll find that the response comes quickly. In places like Fort Wayne, we saw surveys that were replied to in under 24 hours with significant portions of the membership.
Gotcha. All right, the last one for you here is, what you've said has made sense to me, but where do I even start? Where does this solution come from?
Well, it comes from you and from your members, and that's the beauty of the model, right? You start with the survey. Your members tell you what the issues are specifically, depending on the design of the survey itself. They tell you what the issues are that they are most concerned about, and they tell you some of the steps that they're willing to take. So you kind of have a starting place. But it's also important to remember that you're not in this alone. ISTA staff is available throughout the entire process from survey through campaign. So we certainly hope that if this is a direction that you're going in, that you reach out and let us do everything that we can to be there with you throughout the process. So I do want to turn it back to the folks that are listening, Alex, and again, pose that question. Right? Given the particular situation that you're facing, is the law the solution in that situation, or are you and your coworkers the solution? So on the screen, you can see that there is a bit.ly link. It's also, Alex, I can't see it, but I hope it is also posted in the chat. Great. I got a thumbs up, so it must be. And that's an example of what some of these questions might look like, and it'll sort of frame it up for you. What are the issues that you're concerned about right now, and what are you willing to do to make some change in your local? So if you take a quick minute to fill that survey out, we'd certainly appreciate it. And then I will pass it back to Alex so we can move on through the panel. Thank you all very much, and look forward to getting to work.
Thanks so much, Rick. Appreciate hearing from you. And if I can ask you to go ahead and mute just in case there are any echo concerns. Thank you, sir. All right. So next up, we're going to hear from two folks. It's going to be Michael McPeak, a UniServ Director with Unit 11, and Sabra Gage, the President of Washington Township Education Association. You two, go ahead and kick things off.
All right. Hi, everyone. Like Alex said, I am the UniServ Director for Unit 11, which encompasses parts of Marion County, Boone County, Hamilton County, Tipton County, and all of Clinton County. And I also get the privilege to work with Sabra Gage at Washington Township Education Association. And we are here today to explain to you how Washington Township went from 100% in-person instruction to 100% virtual instruction in just about 2 weeks. So Sabra, I'm gonna let you go ahead and explain What happened? Don't forget to unmute yourself, Sabra.
I do this every time. Sorry about that. Hi, everybody. My name is Sabra. I've been the president of WTEA since 2014. I'm a full-time Read 180 teacher at West Plain Middle School, and I'm going to talk to you about how we organized and engaged our membership to push for a virtual start for this school year. I'm also going to tell you I'm extremely nervous. I'm trying to tell myself I'm only talking to 13 people rather than over 500. So please forgive me if I talk too fast or I mispronounce a word. Throughout this process that my team worked on, we held 3 mindsets: keep the pulse, adapt, hold the line. And during this presentation, I'm going to point out where we used these mindsets. So just keep those in mind. So we're going to start with the timeline. We had our first district reopening schools task force meeting on June 23rd. And at that meeting, the superintendent decided we only needed 1 more meeting, which shocked the teacher representatives. Between that day and the end of the week, WTEA had heard from many members about their concerns with reopening on time and at 100% capacity. Admin was made aware that WTA wanted to discuss a gradual reopening plan and emailed the superintendent requesting that this concept be discussed at the June 30th task force meeting. The superintendent did not allow discussion of the topic. Because of this, I spoke to Michael McPeak, our UD, and I spoke to our WTEA officers. And we decided that we had to call an all-member meeting very quickly. So July 2nd, we had our first ever all-member meeting, which led to our first call to action on July 3rd. On July 6th, the board voted to reopen at 100%, but they also said they wanted there to be more discussion on what a gradual plan would look like. Long discussions were held about the gradual plan ideas that week with administration. That led to another member meeting on July 9th. Because of the member meeting input, our discussions with admin on July 10th were transparent, but frankly, they were very, very difficult. The answers to some of our questions caused us major concerns, which led to a Facebook post and a second call to action. The Facebook post shared major concerns regarding the safety protocols and supplies on hand in our district. Finally, on July 13th, the board voted to go 100% virtual for the start of the school year. Even though the board voted to start school virtually, we are still having tough conversations about the plan. That takes us to member input, or where we are keeping the pulse. So think of member input as a way of keeping the pulse of your local and even of your community if necessary. During our Zoom meetings, we use polleverywhere.com, which is a way to survey your people and then show the instant results. We prepared a list of questions regarding the opening of schools to help the WTEA discussion team best advocate for its members. About 50% of our members showed up to both of our Zoom meetings, and this was our first attempt, so we thought that was pretty good. I'm going to tell you just a quick example of one of the polls that we used to get input. So on our first meeting, our first question was, do you support a gradual reopening plan? And 94% of those who were in attendance said they did. Our next question was, do you want WTA to push the district to change to a gradual reopening plan? 92% of those in attendance said they wanted that. And then our lists went on from there to get more input. Many of our team are avid social media users, so they were reporting back what posts they were seeing from colleagues. We used that input to help us gauge how members were feeling about reopening of schools and to tailor what we were doing. We collected member stories written as letters to help board members understand the realities facing teachers in their personal lives because of COVID-19. Some of the stories were heart-wrenching, as people had loved ones who had died, or they were currently dealing with someone who had COVID in their family, or they themselves were dealing with it. We removed their names to protect their identities and then emailed them to the school board before they voted. We received more than 30 stories to share with the board. These stories also helped to inform our advocacy for members. Our team's phones and emails were blowing up with messages from members and from parents. So then how we used that input, we're going to talk about, this is one of the ways the mindset of adapting came in useful. And Michael, there we go. Thank you. We know that we're stronger when we stand together, and we know that together we can accomplish things that we cannot accomplish alone or by ourselves. So when the task force didn't work to have voices heard, we had to adapt and find a way to get our message heard and to make it one collective message so that we were standing together and not standing as individuals or alone. This is how our first all-member meeting and action steps for members came about. Because we stood together and because we gathered input, we adapted our message during formal discussions with admin, and there were multiple meetings with admin. Additionally, we started conversing with the community and parent organizations whom we already had built relationships with over the past several years. We started expressing to them what our members told us they were feeling and what our members said they wanted to see happen, so that we could build the support for teachers' voice and teachers' concerns in the community. We knew members wanted to keep up to date, so we used the Zoom meetings and email updates and social media posts to keep them informed and engaged. Activating members. So at some point in the process of advocating, there comes a time when a decision to hold the line must be made. What is it that we won't or can't accept? It has to be the bottom line, the very least you have to have. And that call can be very tough. Our bottom line was that teachers' voices needed to be heard and respected. So our membership became actively engaged to ensure this happened. In our calls to actions emails, we provided our members with templates to copy and paste into their own email message to the board and to the superintendent. Our first call to action with our first round of emails ended up with the superintendent of our district saying in a public board meeting that she received 41 emails from the WTEA's email campaign over the weekend. That's about 10% of our members. And then I emailed the school board the 33 member stories that had been shared with our team. Our team used their phones also to reach out to people they had relationships with, whether it was a member, a potential member, a parent, or someone in the community. Our team shared what teachers wanted regarding the reopening of schools and checked to see if the person was in agreement or receptive. Then we made an ask. We asked that they contact the board, and we asked that they contact others they had relationships with to do the same thing. Not very long after that, there was a buzz all over social media, and there were emails flying to the board. And again, all of this is happening in a weekend. Our first call to action happened just before the weekend of the 4th of July, and this one happened Friday afternoon and Saturday morning. The second round of emails that I just spoke about after the Facebook post resulted in the board stating in the public meeting that they received more emails and phone calls on this issue than any of them had in a past single weekend on a topic in their entire career as a school board member. Having said that, here's some lessons that we learned. Using social media is awesome, but make sure you use a graphic to grab members' attention. Our social media posting on Facebook has gained leaps and bounds in viewers. And it's all because we started using those graphics. Set up rules and expectations for participants before the meeting so you can be productive. We thought we had told our members what we wanted to have happen at the Zoom meeting. It didn't quite happen that way the first time. So don't be afraid to redirect your members in a meeting like that so you can keep the focus and find out what they want, but don't let them take over the meeting because you have things that you have to do with what they tell you. Keep your UD informed of the pushback or the fallout with administration, because when you take this kind of step, there is going to possibly be some fallout. And you can work through it as we have, but it can be a little scary at times unless you have that support system around you saying, yes, we're all in this together. Know your Zoom limitations. When I go back to think about our first Zoom meeting, People came on and suddenly all of our phones were blowing up. There's a limit of 100. And we were like, oh my gosh. So we quickly adapted, got our payment in, and we had almost 200 people show up to our meetings. Have an easy way to poll or survey members, like I said, the Poll Everywhere, and get advice from your UD about how to proceed with member action without legal ramifications. When we created our templates so that people could copy and paste, we tried to make sure that what we said would keep them out of trouble. Michael, is there anything you think I've missed?
So there are a couple of questions for you, Sabra.
Uh-oh. All right, let's go.
They're easy questions, don't worry. So what does your membership look like? How many people, what percentage do you have currently?
So our membership is over 50%. We're somewhere between 55 and 60% of the teachers in the district.
And then when members were contacting parents, how did they do that? Did they use parent lists and emails from like classroom lists, or did they use their personal connections?
No, when we reached out to parents, it was all personal connections. And I specifically told members that they should not be using their class lists, that it needed to be purely on the relationship you have built. So I don't know what it's like in other school systems, but in ours, some of our teachers are connected via their cell phones so that parents can text them, or they have a Google Voice account. But a lot of our teachers are friends with people in the community, and so that made it easier.
The other thing I want to point out is that even though Washington Township has moved from 100% in-person instruction to 100% virtual for the start of the school year, the conversations aren't finished yet. They are still meeting consistently every week, multiple times, because the plan is not finished. And WTA is not finished advocating for its members. And so I think as a final thing that I would like to share with everybody is stay strong. It's hard sometimes, but stay strong. Stand strong for your members, and know that you are advocating on behalf of those people. And so you're doing the right thing.
And Michael, I probably forgot to say this at the very beginning, even though it was in my notes to say. So one other thing I'd like to add is I'm speaking on behalf of my local and my team, but I want to make sure everybody understands I did not do this alone. I had asked for 40 leaders in our membership if they wanted to participate. 20 of them were able to because it's summer. That's more than what we normally have participate for discussions and working on this. My team was phenomenal. They were committed, dedicated. We've spent lots and lots of hours together on this. So that is the most important lesson I would say that I took away from this, is I was able to build my team larger because this was something that all members were interested in. And now I have more people to activate in the future.
Awesome. In line with that advocating and engaging piece, can you explain how exactly the phone tree worked?
So it was, I'm sorry, it was just kind of a brainstorm when we were talking where we said, hey, what if, let's start with 10 people. Contact 10 people you have a close relationship with and you think might be on our side. Start with 10 and see what you can do with that. So that's how it kind of started, was we just started off with who we were really close to and thought would be on our side for this. And then we asked them to reach out. And once people realized how easy that was, they kept going down their list of people. So we weren't just contacting 10, we were contacting everyone we had a really good personal relationship with.
And it really, what it boiled down to was it was an organic thing that happened, right? So they contacted their people first, and then if those people were on board, they asked the people they were calling to call people. And so it just kind of spread organically without it being a really planned activity.
And I'm just going to expound on that just a little bit, Michael, but with a different twist.
Yeah.
That's what I'm talking about when I say adapting. So this whole process was adapting. We were adapting to our members' input. Because in the beginning, everyone thought the reopening plan was going to be okay and the task force was going to be okay. When we realized that that wasn't going to happen, then we had to adapt. We got information from our members. They said, yes, push the gradual reopening plan. Okay, we pushed it. But then we got more information from our members and from the data about COVID, and they said, now, no, we're not okay with gradual. We don't want it to open. We want to do virtual. It's not safe. So when we started getting all of that feedback, we had to adapt again to the new message of we wanted all virtual.
I'm going to hop in with another question for you two. And actually, Rick, you might weigh in on this as well, depending on what you think, since your presentation covered a similar topic. And the question is as follows. My district has membership below 50%. How can we effectively use the challenges of these times to promote membership so that we can be stronger as challenges arise throughout the school year?
Sure, I can jump in a little bit. My experience has been that effective active action campaigns are one of the most effective membership recruitment tools that we have at our disposal. And I will say, as an example, in Columbus Educators Association, which I was speaking about earlier, they are also using the same approach to reopening issues. And in the past week alone, they had 10 new members come to them. These aren't folks that they reached out to. They came to them with membership forms in hand. And the message across the 10 was basically, we see you guys out there fighting for us and we want to be part of it.
And I think that that's the message there, right? Like, we're advocating on behalf of all teachers, but the mentality and the mantra of we're stronger together and together we can do more, it really resonates in this time because people realize that we're standing for more than just our members. We're standing for every employee in the district, right? And so I think it's important to remember that anything can be used for a membership drive, and we should use it to get more members and to engage our current membership.
And I would just piggyback on what they said and say that in our local, we just had 2 people join that have refused to join for years. So don't give up on potential members or somebody who said that they're not going to join, because everything that's happening right now that we're trying to take care of for our members and advocate and make sure that they're taken care of, people are paying attention to that and they're going to make a different choice this year.
All right. Ooh, am I cutting anybody off? All right. We got one more question, I believe, for this set of panelists, and it runs as follows. For social media campaigns and contacting the community, did people identify themselves as members of the local association?
That's a fair question. So what I can tell you is that for our local, our media campaign was take what we posted on our WTEA info page and share it. Some of our teachers felt comfortable in saying that they were a teacher and how they were feeling. But for the most part, I think they were taking our message and just sharing it on. I will try to look up some of our stats and share those out if somebody can post those on the chat for me.
All right, actually one more, and then I'm going to turn it over to Eric. But Rick, I'm going to ask you to answer this one because I believe it is for you, but I do answer that you give, or request that you give, a relatively brief answer. How do you suggest dealing with member survey results that show a plurality, but not a majority on an issue regarding reopening?
Yeah, that's a really good question, and sometimes you find yourself in that situation. I think that in most of those cases, the best thing we can do is to bring folks together and have the conversation. Some of these conversations are tough, but you know, we as local unions, we have to decide what the issues are that we're going to engage in, and that decision is ultimately up to your membership and their representatives.
Thank you, Rick. Go ahead and mute yourself. All right. Any final words from Michael or Sabra? Feeling all good? All right, I see a thumbs up.
Sorry, Alex. Just somebody was asking about the engagement. So we had one post which reached 9,600 people, and the engagement was 3,700. And that was, I would say, the fuse that lit the entire decision about the virtual reopening and caused everybody to get on board and email the school board. So I hope that answers the question.
Thank you. All right, thanks very much to both of you, in fact. And next up, we're going to hear from Eric Hilton. Eric is ISTA's legal counsel, and go ahead and kick things off.
Thanks, Alex. Again, my name is Eric Hilton. I'm a partner at the law firm of Riley, Bennett, Negloff in Indianapolis. I've been representing ISTA for going on about 23 years. The first thing I want to say is Rick's first slide said there are two types of problems, and my picture was on one side. I'm not sure exactly how to take that. If I am one of the problems or not, I'm hoping that meant from a legal standpoint, but it does say two types of problems, and I'm one of them apparently. I'm going to go over a lot of stuff that deals with some of the stuff I talked about at summer conference and some other conferences. Happy to take as many questions as you can send in if those are the questions that you want to deal with. But a couple of the things that we get questions on all the time and things that people want to know about are dealing with, for example, the new laws that deal with paid sick leave and how those work. First one I want to talk about is the Emergency Paid Sick Leave Act. This act applies to all school employees. It applies to full-time employees. It applies to part-time employees. It currently expires on December 31st of this year. So unless it gets extended by the government, it will expire then. So what it requires is a school has to pay up to 80 hours of leave to full-time employees who are unable to work or telework for some of the following reasons. And when it says 80 hours of leave to full-time, in a normal situation, if we have an educator that has a contract that says 7.5 hours per day is the amount of time they work, you would take that times 5, that's 37.5 hours, times 2 is 75 hours. So generally the way the law is written, it would provide you 75 hours. It's basically the number of hours that you're going to work in 2 weeks. If we have ESPs that are working 25 hours a week, then normally they'll probably get a 50-hour benefit from that. It's the average that they work over the 2-week period. So the way that can be used is if the employee is subject to a quarantine or isolation order related to COVID-19. In that type of situation, so let's say you test positive for COVID, the school corporation asks you to stay at home, then you could potentially be provided with this 80 hours of leave. Now, if telework is possible, if the school corporation sets you up and says, we're going to go ahead and allow you to, while you're quarantining, we're going to go ahead and allow you to do your teaching from home, if you're physically able to do that, obviously, then they may not have to use those 80 hours. The other one is the employee has been self-quarantined by a healthcare provider related to COVID. And usually the belief on these types of things has to be that either the employee has COVID, may have COVID, or is particularly vulnerable to COVID. So this would include employees that are in high-risk groups and have been told to quarantine due to high risk. So if you have somebody that has respiratory problems, heart problems, and the medical provider says that right now I think it's too big of a risk because of a COVID for you to be able to go back to work, they should be able to use those 80 hours in those situations. I've got a lot of questions about members who are pregnant. I believe that if they get a note from their doctor saying that they're medically vulnerable to COVID, they're going to be delivering in a few weeks, then I think we're going to go for those 80 hours on those types of situations. The third category is the employee is experiencing symptoms of COVID and is seeking a medical diagnosis. So if you have a fever, you have headaches, you're doing those types of things and you need to take time off, maybe it takes you 2 or 3 days to get into your doctor, maybe it takes you 2 or 3 days to get a test done. This particular coverage includes time for making and attending appointments to determine your medical diagnosis. So those 3 can apply under the 80 hours. The fourth one is a little bit different. It kind of turns a little bit as to what it provides. is the employee is caring for an individual who is subject to a quarantine or isolation order. It could be more than a family member. It could be somebody that you routinely care for. That if someone that's lived with you for a long time, things like that. It can be basically anybody that you normally provide care for, such as a parent or partner or somebody like that. But the big thing on that has to be, because I've had questions about, my wife is pregnant, she's being put under quarantine, and can I take the 80 hours to take care of her? The law specifically talks about that if the person is capable of self-care, you're not going to get the 80 hours. So if your wife is pregnant, if she's on bed rest and there's nobody else there to help her and she's on being quarantined, then yes, maybe you get the 80 hours. But if the doctor just says, hey, I'd like for the wife to stay home because she's delivering in 2 weeks and has a fear of COVID, then it's probably not going to be enough just to say I need to look after my wife if she's capable of self-care. In the last category under the Emergency Paid Sick Leave Act deals with the employee is caring for a son or daughter if the school or place of care of the son or daughter has been closed, or the child care provider of such son or daughter is unavailable due to COVID-19 precautions. I think I might have seen one of the questions that came across, somebody asking about whether or not this can be intermittent. Generally, it can be intermittent if the employer agrees to it. So it's not something that's automatically that can be used intermittently. But if your employer allows you to use it a bit here, a bit there, if you need to watch the child in the morning, but not in the afternoon, or you need to do a couple hours here, a couple hours there, then if the employer agrees to allow it to be intermittent, they can do that. If there is another caregiver available, it may not apply. So for example, if we have a husband and wife that are working in the same school corporation, it wouldn't be able for both of them to take off to go home and care for the child, because you only need one caregiver in those types of situations. So for these types of leaves, for the first three reasons, which is basically COVID is affecting you in some way personally, it's your daily rate of pay capped at $511 per day, and can be no more than $5,110 for 80 hours of leave. So basically, $511 a day is probably going to get everybody under, or is going to cover everybody for what their salary is, more than likely. But then if it's, depends on if you do 75 or 80 hours, basically just look at it. The rough way to look at it is you'll get paid for 2 weeks of time that you would be out. For reasons 4 and 5, which this is more of when you're caring for another individual, it's got to be 2/3 of your daily rate, but it's only capped at $200 a day. So it's a lot lower rate. And it can't be more than $2,000 for the 2 weeks of leave. So there is a big, if it's because you have COVID or concerned about COVID, it can be up to a little over 5,000 total. Whereas if you're caring for someone else, it's only around 2,000. Now this is a one-time 80-hour benefit. So if school starts, you come down with COVID, and you use your 80 hours, then it's a one-time benefit for everybody. If something happens 2 months from now, you're not eligible to use it again. There's even some information I've seen that if you use it 80 hours and then you leave and go to work somewhere else, that you can't get a new 80 hours with a new employer. It's basically a one-time benefit for everybody that does qualify. One other thing that's a big issue, and we've seen this question come up, schools cannot require you to use any of your normal pay time off before using the 80 hours of leave. So the 80-hour leave comes first, you get paid for that, and then you can use your paid time off after that. I've had some questions, and I will say honestly, I don't know exactly, because I think it's trying to be determined. There's been my original understanding that schools will be reimbursed for this. Now there's some question about whether or not schools will be eligible to be reimbursed for these 80 hours. That's still being worked on, but I have seen some information lately saying that there is some concern as to whether or not schools will qualify for the reimbursement portion of it, but I don't know exactly where that stands at this point. Any questions on those, Chad? Or I can go into maybe I'll just do the emergency family leave. It kind of piggybacks on that. So the other part, the one other benefit that's available is the Emergency Family and Medical Expansion Leave Act. This basically kind of goes along with FMLA. Again, it provides benefits for an employee who's unable to work or telework again. If you can telework, like many of you did when school shut down last year, it's not going to apply. So you're not able to work or telework due to the need for leave to care for a son or daughter under 18 years of age if the school or place of care for the child has been closed or the child care provider is unavailable because of a public emergency. So one of the questions I get was, for example, Washington Township. Is Washington Township closed because they're going in all virtual learning? The Department of Labor said yes. So Washington Township, if your child goes to North Central High School, they will be considered closed for purposes of this benefit. So if you teach in Noblesville but your child goes to Washington Township and they're on virtual learning, then there's a possibility if there's no other person to watch your child that you may be able to get this benefit to watch your child, because that would be the school that is full-time e-learning is going to be considered closed under this provision. Any of this leave counts towards your 12 weeks of FMLA leave. So if you're off for 12 weeks, you've burned your FMLA for the whole year. So it is an additional benefit, but you burn it for the year. The first 10 days of this leave are unpaid, but an employee's sick days can be used to cover the first 10 days potentially, or the Emergency Paid Sick Leave Act that we previously talked about, that may cover the first 10 days, and then you move into this other thing if it goes beyond those 2 weeks. Now, this provision, if you use the full 10 weeks, the leave must be paid at 2/3 your daily rate. But again, similar to the other one, it can't be more $200 a day and no more than $10,000 total for the 10 weeks of leave. The school corporation can allow an employee to supplement the remaining 1/3 daily rate with leave days, so you can use 1/3 of a day for each day you're out to cover the rest of the money. And again, leave can be taken intermittently, such as if the employee is teleworking but needs time off to care for a child periodically. So let's say you're doing telework, but from 2 to 4 p.m., there's absolutely no one to watch your child. Now, when it says there's no other people available to watch your child, it's you don't have to go out and go to every single child care facility to see if somebody can watch them or call everybody you know. But if there is somebody that would normally watch them, that they can ask you some questions and they can require documentation to be provided to make sure that you in fact need to be home and be the one that is looking after that child because their child care facility or school is closed. So that's kind of a general recap of those two laws. Chad, do we have anything that or Alex that might get thrown in here?
We have several questions, some more specific, some more generally about workman's comp and coverage dealing with COVID. Could you just generally talk about that topic, and we'll
sure.
see how many we can answer?
Sure. I've seen arguments on both sides of this, and I've tried to do as much research on it as possible. I think if it doesn't hurt if you get COVID to file for workers' comp, but a lot of the legal interpretation I've seen is that it may not be something that would be covered by workers' compensation, that workers' compensation might treat it similar to like catching the flu virus at work. An example I always use, if you have mold in your classroom and the mold makes you sick, then that was a injury that you sustain as a result of your work. If you catch the flu at school, you're not sure if you got the flu at school, if you got it at home, or where you got it. With COVID, at least initially what I've seen from workers' comp is that it may be treated the same way, but again, it's kind of early in the process to know for sure. If you really haven't been around anybody else and then it determines that you got COVID at school, I think a claim could be filed. But I think until we get a little bit further into this and we see what decisions the workers' comp board is going to make, I don't think there's an absolute answer at this point.
We had a question about possible violations of FERPA and educators live streaming from their classroom.
Sure, and I'll as we go along, if you just shoot me questions, that's fine too. I've got that another part of that of my presentation. But as far as that's concerned, I do have some concerns with privacy protection for distance learning situations. I think the most important thing for you to do if you're in that situation is to follow whatever school policies have been put into place. The FERPA issue that I have concern with is that, let's say you're doing a hybrid model or where half your kids are coming in and half are at home, or you just have a virtual learning option and you have 22 kids in class and 4 kids at home that are doing it virtually. Under FERPA, if you're in a situation where you're disciplining a child in class and that is being broadcast to kids at home, and then the parent at the home of the child that's there is watching it, and they potentially put it on Facebook, look how Johnny got disciplined in class, he's such a pain, those types of things, that in my mind would violate the child's privacy rights. Now, I've heard from other attorneys who have argued that, well, it doesn't necessarily violate the privacy rights if simply the child who's doing the home learning is watching, which I agree with, because that child would have otherwise been in class and been able to see Johnny get in trouble. But the problem becomes whether or not the parent has access to that video, if they can see it, if it can be recorded. In some situations, I know of schools of kids that are learning at home, they might have them sign a waiver saying that they agree that it will only be used for educational purposes, they won't repost anything. In other places, whether or not the parents of the kids being recorded in class would need to sign any kind of a waiver saying that they give permission for these things to be streamed to others. In the end, that's kind of my view on it. But in the end, it's not really our problem that much, because in the end, the school corporation makes the ultimate determination as to how they're going to do it. Any violations of FERPA would ultimately go back on the school corporation, as long as you're complying with the school corporation's policies. If the school corporation has a policy that says we're only going to do it in this format, but you prefer Zoom and you do it during Zoom and somehow it gets recorded and goes out, there could be potential disciplinary issues on your part by your corporation. But an actual FERPA violation or privacy rights issues, if anything, it's going to come back on the school corporation. So I don't think there's really any exposure on behalf of educators. As long as they're following the school policy. I would bring it up maybe in discussion about some concerns that you might have, but in the end, the school makes the decision on that part. You're required to do what the school asks you to do, and I don't see any liability for any of you by following school policy.
We had several questions, Eric, about along the lines of if you are quarantined multiple times, if you get sick multiple times, and it looks like most of the questions are in terms of what leave is available. What's the hierarchy? And I think you mentioned this a little bit earlier, but what's the hierarchy of the leaves as they would apply?
So the first you would use would be the 80 hours of leave if you've been quarantined, if you've been told to self-quarantine or you're experiencing symptoms. So you could have a sore throat, you can have some asthma problems, things like that. And then at that point, you might be seeking medical diagnosis. So in almost all these COVID-related situations, if it's medically related, the 80 hours should be able to come up front. If you only use 20 of those hours and then you get sick later, I think you can continue to use hours up until the 80 total. But those would be the first. Again, school corporations cannot require to use your own paid time off before the 80 hours is provided. And then after that, you would have the availability to use your own sick leave if it's not covered after the 80 hours. A possibility of using a sick leave bank if your school corporation has a sick leave bank. And then depending on if it's just a medically related thing and it's a severe disability, you could potentially go all the way out and use 12 weeks of FMLA leave that at some point, if your sick bank doesn't cover, you don't have enough leave days, you might have to take that unpaid. So that would be the general progression. It would be use the 80 hours up front, then use your own paid time off, possibly use a sick bank if you qualify for that, and then the possibility of using some unpaid leave if you're in a situation where you don't have any leave left. Now, if you have a situation where this is something that you can, I think, do locally with your school corporation, is if you're in a situation where this year pretty much everybody's taking away attendance incentives. They're going to tell everybody to stay home if you're sick or you have COVID symptoms. You might want to talk to your corporation about what do we do that this person has had strep throat two or three times this summer, and now they're burning through all these days. Is there something we can do? And I think considering the circumstances, I think you have the potential of possibly reopening your contract and bargaining some additional benefits. But that's also something to consider. So there's a lot of options that are available, but the 80 hours up front is a very good benefit and should be used if you have any COVID related situations.
We have some questions, Eric, regarding OSHA and the fact that they are not, their regulations are not necessarily applicable to schools.
Right.
Kind of that whole idea about workplace safety, and if it's not OSHA, who is it that governs that for schools for Indiana?
Sure. So OSHA does not apply to public state schools in Indiana, but IOSHA does. So it's basically Indiana OSHA, and it pretty much covers the same thing as the federal OSHA requirements. So a lot of the things you'll hear a lot of the times about what type of work environment has to be provided talks about the general duty clause, which talks about that a employer must furnish to its employees. It says employment in a place of employment which are free from recognized hazards that are causing or are likely to cause death or serious physical harm to its employees. So, an example they have is you're required to work on a 25-foot lift, doing certain things. There are no safeguards on the thing. There's no belt that you wear that you're strapped in. In that type of situation, you can say, look, you're creating a hazard that could cause serious harm or death. As far as COVID is related, if you have a situation where your corporation is doing absolutely nothing, which based on the governor's executive order that will be coming out, I think everybody will at least have to wear masks. And I think it's going to be pretty common that people are going to have enhanced sanitary situations in place to deal with this thing. I think, if they created a bad situation where people were overly exposed to it, it's possible that they could file something through IOSHA, but I think in the end, it would be a difficult case to win. The facts would probably have to be so egregious to come out in the end as a favorable decision by IOSHA, because I think schools will be putting lots and lots of things in place to try to create, because one of the things they have to do, it talks about whether the employer failed to keep the workplace free of the hazard. The hazard was recognized, the hazard was causing or was likely to cause serious physical harm or death, and there was a feasible and useful method to correct the hazard. So I think in most schools, they're going to say that everybody had to wear a mask, everybody had these increased hygienic procedures. We wiped things down, we did this and that. So I'm not going to say it's not possible to win on an IOSHA case, but I think it's probably a pretty high standard by which a school would have to meet in order for Indiana OSHA to come in and find a school in violation. But it doesn't mean it can't happen. But I just think from a legal standpoint, it would probably be kind of a big thing to accomplish.
Going back to the emergency paid sick leave, the 80 hours piece again for a moment, we've got a couple of questions inquiring about, we know that FMLA can be used intermittently. Can those 80 hours be used intermittently as well? And of course, we know that sick leave days, the use of those are governed specifically under our collective bargaining agreements. So that would be a place people could check for those.
Yeah, the 80 hours can be used intermittently, but it has to be agreed to by your employer. So there's not an absolute right to use them intermittently, but the employer can agree to allow you to do that. So it's not automatic.
All right, I'll hop in with, we got several questions, Eric, that have to do with FERPA and streaming and any rights that teachers might have or ways to protect themselves in that kind of realm around streaming their classes.
Okay. One thing that I've told people to look into is possibly to go into discussion with your local association and your corporation to make sure you know exactly what the policies are, what the procedures are, how the streaming will be done. Try to in the discussion process ask that the streaming portion of the video won't be used for evaluation purposes, and that there's a strict evaluation standard under any law as to how that's to be done, and not that they're going to be in there watching the video every day and then evaluating you based on it. I think you can ask about getting waivers from kids either in the classroom or at home, asking them to sign something that says that this will only be used for educational purposes. You will not use this any further, which again, somebody could sign that and do it anyway, but at least it provides a little bit more protection. So other than that, I didn't know if there were specific FERPA questions or if it's just kind of more of a general thing as to what they can do to protect. I mean, the employer does, if the employer, after going through discussion, if the employer chooses to videotape and stream it, that's their choice in the end after discussion. So they do get to make that decision. But you know, there are some avenues like we discussed to try to go and protect your members a little bit.
I think that answers the questions that I saw, though Chad and Pam, I'll pause for a moment in case you disagree with me or see something different with respect to the FERPA questions you've been seeing. And as you're doing that, Eric, I might just feed you one other question that we're getting a few times, which is basically, is there an at a glance, or will there in the future be an at a glance or something like that for this information, or can you recommend any web pages or?
A lot of the questions that we've been getting, ISTA's been putting up on their website. So we just did another batch a week or so ago that are going up there. So a lot of these things will be going up there. So check the ISTA website. A lot of that Q&A, a lot of times after one of these sessions, they will give me a Q&A, and I'll write out the answers and we'll post them on there. So there is some availability, but let me kind of move into, and if you got questions, just feel free to interrupt me. But another big issue that a lot of people have concern about is dealing with the Americans with Disabilities Act. What kind of protections do we have for our more vulnerable employees and others who are concerned about returning to work because of fears of contracting COVID? Unfortunately, generally a fear of contracting COVID is not enough to allow an employee to stay home from work. You can use leave days, you can use other unpaid, but just saying that I'm concerned about contracting COVID would not necessarily be something protected by the ADA. But the ADA may provide protections through reasonable accommodation. So first, and I've seen this, and if you see this come across your way in your corporation, then let your UniServ director know. I've seen a number of, and I think it's all well-intentioned, but I'm seeing a number of surveys that corporations are sending out to their employees that basically says, please list any and all medical conditions that you have that would make you susceptible to getting COVID. You don't have to answer those questions, and they shouldn't be asking you those questions. So we've gone and helped corporations kind of redo their questionnaire, because it's a situation that they don't have a right to specifically ask you what your medical condition is. If you're a vulnerable medical condition and you choose to work, that's ultimately your choice. There are certain limited situations where if an employer believes you are at such a high risk of possibly severe injury or death that they could put you out on medical leave on their own, but that's pretty limited. But in order to be entitled to protections under the ADA, you must have some sort of a disability, which is defined as a physical or mental impairment that substantially limits a major life activity. Examples of disabilities, it could even be alcoholism, asthma, blindness, cancer, depression, diabetes, epilepsy, hearing or speech impairments, heart disease, migraine headaches, orthopedic impairments, things like that. And there can be others. The disability must then substantially limit a major life activity, and such major life activities can be eating, sleeping, standing, walking, speaking, bathing, dressing, and shaving. So basically day-to-day life activities that because of your disability, you're unable to do. If you do have a qualifying disability under the ADA, the employer must then consider whether the employee can perform the essential functions of the job with or without an accommodation. So if a reasonable accommodation can be provided to the employee, they have to look at whether or not it would cause an undue hardship to the actual employer. And the undue hardship standard is a pretty high standard. They can't just say, well, this would make it difficult for us to provide. They have to really engage in the interactive process with the employee to determine if there's some kind of accommodation that can provide them. So for example, at the end of this past school year, there was no question that a reasonable accommodation could be provided to an employee, allowing them to work from home and do remote learning. However, this year, if you're in a corporation where all students are returning to class, or there's a hybrid model or things like that, it may not necessarily be reasonable to allow the school employee to stay home and teach the class when the entire class is in the actual school building. So in those situations, what exactly is considered reasonable What may be reasonable in one place may not necessarily be reasonable in another, and there could be a lot of factors that go into that. But the important thing is that if you have teachers, if you have other employees or other members that are in a vulnerable category, they have a disability, they have concerns, if you haven't already started the process, you have every right to go to your HR director. Usually is that who you would go to, identify the disability that you're talking about, request accommodations. You're more than likely going to have to provide medical records from your doctor that will demonstrate that you do have this disability. And then they are required, they can't just say, well, I'm sorry, there's nothing we can do for you. They are required to do an interactive process with you in which a decision is made as to whether or not they can provide an accommodation. For example, accommodation could be that you're not required to leave the area of your desk, and they put up some sort of plexiglass shield around your desk. I mean, that could be an accommodation. Could be an accommodation that there's a certain area around your desk that the kids are not allowed to get any closer. Could be an accommodation that all the students have to wear masks, potentially, but hopefully with the governor's order, we won't have to get into that situation very often. Which, just based on that, I saw this morning that the Indiana Attorney General is saying that the governor does not have the authority to issue that order. So I guess we'll see what happens when that comes down, when he actually writes out the actual executive order. Yes.
Do you mind if I feed you a couple sort of like rapid fire
Sure.
questions?
Mm-hmm.
Okay. So one of them is, what about kids with IEPs and confidentiality? Do they have to have one-on-one teletherapy, or can they be in a group? Questions around streaming more broadly as well when kids with IEPs are involved.
I'll be honest, I'm not really the person to answer IEP questions, because the reason for that is we very rarely are ever involved. It's usually corporation or attorneys for the school corporation that gets involved with the IEP process. Really, in the end, the most important thing I think when dealing with IEPs is any plan that you're going to have in place of how to service your students that have IEPs. Make sure you have a conversation with your corporation, get in writing how they want you to do it, regarding the privacy and everything, because I know there's a lot of situations now that, IEPs are probably being violated, or at the end of last year when there wasn't able to be in-person learning and things like that. But the key in that situation is talk to your administration, get direction in writing from them as to how they want you to do it, and then follow that thing. That's going to protect you. They're ultimately the ones that has to decide and talk to their attorneys as to what has to be provided. But right now, it's from talking to school attorneys that I know that are dealing with the situation. It's so difficult right now because it can be nearly impossible at times to provide the services that they're required to provide by law. If a lot of those kids are vulnerable themselves and they're not even able to come in. So it's important to have a conversation with your administration, get them to put in writing how this is supposed to be done. Don't just try to do it on your own and figuring out what's best for that kid. Get guidance from your administration and then follow that, and that's going to protect you.
All righty, and then I'll give you two more on streaming questions. So one is, are there also copyright issues when streaming live? For example, reading out loud from a published work.
I think from that standpoint, it would pretty much be the same copyright issues that you would have in the classroom. If you would read an entire book and then somebody would post that on there, that might be a little bit more problematic. But I think the general practice of how you just use portions of books or things like that, I'm not real concerned that there'd be copyright issues that are going to come up.
Do corporations have a right to use streaming for evaluation purposes, or streamed classes for evaluation purposes?
I think our position on that needs to be no, because there is an evaluation process. Now, I can't say that if you're seen striking a child on video in the classroom, that they couldn't use that in some sort of disciplinary fashion. But I think it's important as a part of discussion, because people ask me when we deal with allegations that are made against teachers and with Department of Child Services or something, they say, why don't they just have cameras in all the classrooms? And I think one of the things is that because that teacher, it makes it very difficult for them to teach. They feel like they're being evaluated every single second that they're in the room, and they're being watched all the time. But I think you can have a discussion with your administration about specifically saying that these are not going to be used for evaluation purposes. Obviously, if there's severe misconduct, they can, but requesting the corporation to still go through the standard process of evaluation where they come in and you're observed and go through that process. So I can't say that they can't use it necessarily, but I think it's something that you need to take to discussion and put your position forward as to that we don't believe that this should be used in that fashion.
I'll give you one more that stood out to me.
Okay.
What are our rights if a parent puts a recorded classroom snippet all over something like TikTok? In our community, we would suffer depending on how things get spun. Do we have legal recourse in a situation such as that?
You would potentially have legal recourse against the parent if they put something out there that shows you or is kind of defamatory or libelous or something towards you, or if it was done intentionally to create harm to you by doing it where it may not be the entire portion of the video. So there would be potential legal remedies and we've had cases in the past where we filed lawsuits against parents for putting images of a teacher or other school employee on websites or taking a picture of their head and then placing it on an inappropriate type website thing. So yes, there are potential legal avenues that you can go down. But again, if although they may violate it, if you have something that's in writing saying that the parents understand that this will only be used for educational purposes, I would push that forward with your administration to say, look, I don't want to be showing up everywhere over Facebook or Twitter or Snapchat or something like that. Can we at least get something from our parents saying that by making this available to them, we will only use it for these purposes? Now, we all know there's going to be people that may sign that document and still do it anyway, but there could be potential legal ramifications if they were to do that.
Eric, we have a question. Well, we have several issues cropping up, but it's kind of under the same banner of the corporation's assignment to a teacher being at home conducting remote learning. And if that's in quarantine, if that's not in quarantine, do they charge the 80 hours? Do they not? How does that relate to if you're actually placed in quarantine versus assigned to remote learning,
right?
Not in person.
As long as you're capable of still performing the job functions, be it through telework or some other fashion, then they can just continue to pay you your regular salary for working at home, and they don't have to use the 80-hour benefit. So if they decide to use the 80-hour benefit, they shouldn't be requesting that you do any work because you're sick and you should be off. So it specifically says if telework is not available. So it really comes down to a situation if you have to be at quarantine and there's nothing that they can find for you to do. I mean, if it's at home and they say, hey, we'd like for you to work on these lesson plans, or we'd like for you to do something like that, they can still assign you work if you're going to be quarantined. But if there's no work for them to necessarily have you do while at home, then the 80 hours would probably kick in. I mean, the employer they can provide additional paid benefits beyond the 80 hours and just continue to pay you. That's a benefit as well. But the actual 80 hours in the new law has to be, you're in a situation where you can't do work away from your employer and there's nothing for them to do. Then the 80 hours would kick in.
We have a couple of questions specifically regarding preschool, be it developmental or perhaps a preschool/daycare option that some school corporations run for the benefit of their employees and their children. Regarding the mask wearing, all students will be wearing masks. Does that not apply to preschool? And questions about again, assignment in the remote learning. We're not going to be remote learning for preschool if the school corporation closes down. Will we be paid for those days? Questions along those lines.
Sure. So as far as the mask requirement, if a school corporation, just because the governor's order says that it'll be for, I think, third grade and above, the school corporation has absolutely every right to require it in second grade, first grade, kindergarten, and preschool as well, if that's what the school corporation ultimately chooses to do. They have a right to make that requirement. Under Indiana law, if you're under a regular teacher's contract, there's an Indiana law that talks about if school is canceled for a reason beyond your control, and it's canceled by the school corporation or a health department, then teachers continue to be paid. Think of it usually the way we explain it is you miss 5 days because of snow. You don't go to school those days, everybody's home for 5 days. You continue to get paid for those 5 days. The way the law works is that if the school corporation then requires the students to make up the days at the end of the school year, you have to work those 5 additional days without additional pay because you already got them for the 5 days when you previously worked. One issue that we're trying to get some instruction from the State Board of Accounts is we've got some school corporations, or a lot of school corporations, that are in a situation where they're deciding to push the start of school back a week or 2 weeks, or they might have started on the 1st of August, now it's August 17th. What about that potential gap in pay, that if people are getting 26 pays, what's going to happen if we push the start of school back 2 weeks? Our position has been that under the argument of, under the statute that talks about if schools cancel for no reason based on the teacher's doing, then they should continue to be paid, and you should continue to be paid every 2 weeks. But there were just a letter sent to the State Board of Accounts yesterday, and I think I saw an email before I came in here that says they're going to try to get a decision to us by the end of today. I think most school corporations are going to try to be in a situation where they'll continue to make sure you guys don't miss out on a 2 week period. As far as classified employees, I've heard in some situations that if school doesn't start back for 2 or 3 weeks, I think school corporations could have the potential of paying those, but they may not necessarily have to pay those. So there's no similar law that deals with coverage of that, but they would still, they'd be paid more when they're worked. So those are issues that we're continuing to work on. It came up at a conversation the other day with some other attorneys. A letter was sent to State Board of Accounts, and we're just kind of waiting to get a response. I think ultimately they'll approve. The biggest concern from a corporation standpoint is, what if we start 2 weeks late and we pay somebody for those 2 weeks, and then they decide to quit and go somewhere else, and they never actually work for us? But the counter argument to that is, well, it's the same thing if you have 5 snow days and you pay that employee for those 5 snow days, and then they make up those 5 days at the end of the year, and that employee is no longer there. It would just be up to the corporation to either request the money back from the employee or take legal action against the employee to get the money back. So I'm just keep an eye on that if your school is pushing back the start date, and depending on the way the Indiana the wage laws work, basically you have to be paid within 10 business days from the end of a pay period. So if the pay period is August 1 through August 15th, you have to be paid 10 business days from that, which is basically 14 days. So the period you work from August 1st to 15th would have to be paid on or around August 29th. So, but the problem is, if August 1st through 15th was going to be your new paycheck of the new year, and you don't start till 2 weeks later, then there's a question of whether you're going to go with a 2 week gap. And we're working on that to try to make sure that doesn't happen.
We have a couple questions that relate to bargaining, Eric. Specifically, those situations where a teacher is teaching in person, but particularly in our smaller school corporations where there is limited staff, then being required to, whether it's creating videos or Zooming with remote learners or whatever the case may be, that work that is done outside of contract hours, should the association be looking at that as an ancillary duty? Is that subject to additional bargaining? How are those extra hours of work, how should those be compensated?
So we currently have decisions from the Indiana Court of Appeals and Indiana Supreme Court that as far as an ancillary duty, additional pay can be paid for ancillary duties, which means not your normal everyday stuff. So we all agree that if you have a 7.5 hour contract, they can still require you to grade papers and do lesson plannings in the evening. That's not considered an ancillary duty. It's just kind of part of your normal teaching duties. But if it's a situation where you have to go to an open house in the evening, if you have to hold hours outside to meet with students or parents, some other things like that, it could be considered an ancillary duty and they could provide additional benefits. The same thing, we've also got a decision that says you can actually have ancillary duties during the school day. So if during your prep period a teacher has to go home sick and you agree to cover that prep period for the teacher, you can bargain additional pay for that one period of time in which you're covering. So Chad, what was the second part of that? I'm not sure if I remember the whole question about bargaining.
Just talking about whether or not that would be considered an ancillary duty, or how exactly do we go about trying to bargain compensation for those
So
hours?
you could bargain additional compensation, but there's also, if you have a 7.5-hour contract, there's not anything that a school corporation can say that you have to stay for an additional hour to do these additional things. I mean, you have a contract. That's I think Rick might have talked a situation that we had in Columbus, and that was basically a situation where the corporation was routinely requiring teachers to stay after school for department meetings and things like that. And you have a contract with a number of hours in it for a reason, and that's what your contract says. Those are the hours that you're going to be expected to work. So you can, if you get in a situation where, because of this, and with a lot of these schools going to this hybrid model, I'm not sure how that's going to work. With teachers being required to both educate the kids in their classrooms and at home. I understand, the reason for doing that, but it could potentially put a lot of extra time and work on these teachers. So if you're having an issue like that, reach out to your local leaders, to your UniServ director, that they could possibly come to me, and we can look at that to see if your contract is being violated. One other thing to keep that, while it popped in my head while I'm thinking about it, Indiana law requires between 10 a.m. and 2 p.m. that you have a 30-minute duty-free period. So it has to be duty-free. You can't be spraying down desks. It can't be just the kids leave your room for lunch and you're there, but you have to spray down desks and things like that. It has to be 30 minutes duty-free for lunch in which you have no other duties. So if that's not happening, then make sure, again, contact your UniServ director or your local leaders, because we want to make sure that's going to be critically important during these times. You guys are going to need a break during the school day if you're in person, and that is a specific law that is required to be, that benefit is required to be provided to you.
Eric, I've got a question to feed to you, but I think one that I'm going to preemptively tack on to what you just said is, can you clarify how that 30-minute duty-free would work in the context of a school requiring the teacher and the students to remain in the classroom for the lunch period?
That's a good point. I don't think it does work. That's not duty-free. I mean, if you're basically duty-free, would have to be those kids remain in the classroom for lunch. You might have a paraprofessional come down and supervise them while they're eating, and then you get your 30 minutes free. So yeah, that kids eating in class, I hear it from special education teachers all the time that they never get their 30-minute duty free. And a lot of times it's by their choice. They want to keep their kids in their classroom and things like that. But if it's a situation where kids are going to be eating in rooms, between 10 a.m. and 2 p.m., you have to be given by Indiana law 30 minutes of duty-free time that is your own. So if that's not happening, we need to look at it. As far as, there's arguments sometimes, as, let's say the bell rings at 11:45 for lunch, for your kids to go lunch if you have a split class or something, or it rings at 11:45 and then it rings again at 12:15. We've gotten into some discussions before with school corporations to say, well, the teacher has to stay there until all the kids get their stuff together, get out of the room, and the teacher has to be back 5 minutes before the other bell rings to unlock the door to make sure the kids can get in the room. And we say, that's 30 minutes. There's only a 30-minute time period. That's not 30 minutes duty free, because they have to stick around to let the kids get going where they're going, and they have to be back early to open up their classroom. So most of those we don't really have a lot of disputes with, but I think this year it's going to be critical that everybody remember that you are entitled. It's going to be stressful. We all know that. You're entitled to 30 minutes of your own time. That's not a prep period or anything like that. It's 30 minutes duty free where nobody can really tell you what to do at that point.
All right, so one that I'm going to read off for you here is a school in our county is requiring teachers and staff to sign a waiver protecting the school from liability if a teacher gets sick. In general, does an employee have to sign a legal waiver of this nature? Can such a waiver be required as part of signing teacher contracts? I think that means like as a job duty, or can an employee decline?
Absolutely not. They can not make you sign one of those, period. So if you have that issue, bring it forward. I was just talking to a school corporation attorney, and their same position was you cannot require your employee in order to come to work to basically sign away any right if they were to get sick or to die, because of, at that point, there's not a whole lot of motivation for an employer to really provide a safe work environment, because, well, if they get sick or die, they can't come back to us for it. So absolutely not. That if that's going on, we have to get that stopped immediately. And I've seen that in several places. I'm not sure where that guidance is coming from. The attorneys for school corporations that I deal with are not advising people to do that. The only situation where we see that where that can be done, for example, you can't have a student sign that to just simply come to school, because by law they're required to come to school. We're required to provide them with an education. They cannot be required to sign a waiver. Now, extracurricular activities, probably every single kid that does an ECA is going to have to sign a waiver saying that you understand by participating in this ECA, this is a voluntary activity on your part, and that if you get sick or die from this, that you're waiving any right claims against the school corporation. So totally to be expected for ECA positions for students, because it's not something that they're required to do. It's something they choose to do, and they can be required to have their parents sign a waiver. But school employees should not be signing a waiver, giving up any rights simply to just be coming to work. So that should not happen.
All right.
That would be something I think we would litigate if that happened.
So at this point, I just want to do a quick bit of housekeeping. So for all of the attendees and the panelists as well, sometime between 12:30 and 12:40, I'm going to open it back up to all of the panelists, and I'm going to feed a few questions that I've pulled aside. So Chad and Pam, if there's a couple more questions that you want to identify specifically for Eric, start kind of putting those top ones together. And then Eric, I'm going to ask you one right now while Chad and Pam kind of look at those final ones. Sure. So Eric, following up on that liability question, could you speak to the employees, so the teacher or the staff's liability with regard to any contact tracing efforts, as well as potential liability for the staff member if, for example, the contact tracing shows that the staff member infected a student and then that student went on to suffer grievous injury?
Sure. And people ask me questions a lot that say, can I be sued for this? And I say, you can be sued for anything. That doesn't necessarily mean somebody's going to win, but people say, can they sue me for this? And I can say, yeah, sure, they can sue you for anything. If it's a situation that someone comes down with COVID and then spreads it to someone else, it's probably would be really difficult to prove exactly how it got transmitted from one person to another. But let's say a teacher has it. The only situation I can see where there could be potential liability for a school employee is if they knowingly have COVID, they decide to still come to school, they're not using masks appropriately, they then transfer the COVID to 3 or 4 kids in their room. I mean, that would be a situation if you decide just to not comply with any of the requirements, you know you're sick, you know you got a positive test and you come to school. Or, I mean, obviously in a situation if someone knows they have it and they intentionally sneeze in someone else's face or something like that. But from a liability standpoint, I think it would be a very, very rare case in which you could be held liable for spreading something if you get it. I mean, as long as you're following the health department guidelines of once you determine that you have it, you quarantine for 14 days, you inform your employer. It's going to happen, unfortunately, in places where there's going to be an outbreak. But as long as schools are doing everything they can to be safe, could there be lawsuits from it? Yes. Would you be covered by insurance? More than likely, yes. But just follow the rules. If you feel sick at all, stay home, and same with kids. So I don't have a real big fear of liability on behalf of teachers and other school employees if they were to ultimately determine, they felt a little sick and 4 days later they found out they were positive, and for a little bit they were around their kids and now their kids have it. Again, there will be attorneys out there that, and maybe that's the whole slide of one half of the problem is attorneys. Maybe that was meant at the very beginning of this. But I think it's a situation where I'm not concerned about liability in those situations. I think schools will be taking precautions to as much as possible to prevent those things from happening. And I think it's going to be even more protection now with the mandatory mask requirements that are. I mean, a school potentially, if your county has a big outbreak, and 4 schools in the county are going virtual, and your corporation decides to go all in person with no masks, thinking of this prior to the governor's order, then that could potentially open up a school corporation for liability by not putting in safeguards in place that were needed based on a reasonable standard in your community. So that could be a possibility, but I think it'd be a very rare situation. Will we? And that's why you're seeing a lot of, when you're talking about the next stimulus or the next package from the federal government, you hear a lot about them wanting to provide schools and businesses and employers with protections from lawsuits for things like that. That if someone contracts COVID from a business or from a job or a kid at school, they're wanting to potentially provide protections for in order to get things open back up, that they can't necessarily be liable. But that's still to be seen. Let me just run through a couple things real quick that I want to make sure I give some information out to people. A couple things: reductions in force. Indiana law says that reductions in force notices can only be given out between May 1 and July 1. We're outside that window from our legal standpoint. Our position is that the school corporation cannot give out reduction in force notices during the school year. There are some attorneys who differ in my interpretation of the law, but I think it's pretty clear, and that's something that we would probably challenge. So if you come to a situation where your corporation is trying to do some sort of reduction in force during the school year, then please contact your UniServ director. ADA privacy protections. The EEOC has said during pandemics and situations like this, your employer can ask you questions as you come into school. They could ask you how you're feeling. They can take your temperature. They can require you to wear PPE, and any refusal to do these things could potentially be insubordination. But again, they shouldn't be asking you about whether you have specific medical conditions. But one other law that's good to know. I haven't heard a lot of places that are going to do it, but where they might ask employees to take the temperatures of students as they come in the building. I think in most places I'm hearing they're not doing that, because that really just makes a big corral of kids that are all standing on top of each other waiting to have their temperature taken, which is kind of defeats the purpose of trying to do social distancing. But there is an Indiana law, and your UniServ director can provide this, that specifically talks about that a school corporation cannot require a teacher or other school employee who is not a school nurse to administer medication to students or to provide healthcare services, basic life support, or other services that require the teacher or employee to place the teacher or employee's hands on a pupil for therapeutic or sanitary purposes. So one of the things it says it can't require a school employee to provide healthcare services. There could be an argument that taking kids' temperature would be a healthcare service because you're trying to get medical documentation for something. So there might be a way to push back on some of those things. I think that's, we covered the page, and that's the majority of things that I had kind of that I wanted to cover. So if there are a few more questions, then I'm happy to answer those.
Yep. Looking at the time, let's do our best to keep it quick. But Chad, I think you had one that you wanted to hop in with.
Yeah. A quick question, Eric, about your job responsibilities if you are in quarantine and you're not otherwise assigned to do something by the school corporation. So you're at an in-person school, you're subject to quarantine. Are you then obligated to do lesson planning, videos, any of that other sub-plans, any of those other things?
The advice I've given is to treat it kind of similar like you might do on any other sick day. You know, they can probably say, hey, you need to send in some lesson plans. I mean, that might be provided up front. I mean, I think there's probably that expectation for most educators that if you end up getting sick, we need you to leave behind some lesson plans for the kids to do. If you're truly sick, then they can't require you to do work at home if you're not capable of doing it. But where you need to look at it and as a possible advantage is that if they're saying, okay, while you're at home quarantining, we want you to do this, and this, you should get your regular pay. They're asking you to stay home and do work while you're home. So then you save those 80 hours. So, you know, be careful in situations where the corporation says, hey, you know, this qualifies for those 80 hours. We're going to pay you under that provision, but we still want you to do all this work. My response would be, no, wait a minute. The 80 hours comes in if I'm not able to work or telework from home. You're having me do work at home. I should just continue to receive my regular salary. Because that's what everybody did when all the schools shut down and everybody had to go home. They were getting their regular salary during that time. So basically, if they're asking you to do a fair amount of work, I think you take the position that they're just continuing to pay me my regular salary to work from home as opposed to using those 80 hours.
All right. And Pam, did you have a last one that you wanted to make sure got addressed?
There's been a lot of interest in asking questions. I'm not sure that we can get every single one in, but I would just say generically, some of the questions have been items not specific to COVID. For example, summer pay rates, things like that. For those of you who had questions like this, please reach out to your local association leaders and your UniServ director in your area. That's the best way to get responses to those questions that we haven't been able to touch on today.
All right, thank you, Pam. Okay, so I see Sabra's got the camera back on. I think what we'll do now is we'll switch over to a couple questions I want to throw out to the whole panel. And I'll have to wrap us up around 3 minutes to the hour, just to make sure that we give Keith a chance to wrap things up for us as well. So the first question I want to put out to folks is, let's see. What will happen if we are not provided with proper PPE, get COVID, and the governor has taken our rights to sue the school system away?
I really enjoy the framing of that question. You know, I think that is a question that is going to require us to kind of raise the volume level a little bit if that becomes a situation that we find ourselves in. You know, I think of it in terms not necessarily so much as a lawsuit, if the lawsuit's been taken away, as potential legislative compensation. You know, our employer is the state, our employer is the public. You know, we can make the case that the public has some obligation. I think there. I think similarly to public employees that have been had consequences in the face of other disasters, that there have then been subsequent actions that have been taken to make resources available in compensation for those. I think that we could certainly lobby for such a response.
And I think so much of it, and I will kind of add to my portion of it, it's all kind of has to be done with a disclaimer right now that, you know, everything that we're providing today is everything that we have the best knowledge of as of today. Some of the answers I gave a week or two ago have changed somewhat, slightly. But I think it's a matter of us, you know, keeping an eye on of what comes out in this next package. Is it liability protection for corporations for being sued by students? Does it also apply to employees? I think in any of those situations that as long as you're a member of the association, that if that comes up, if you see a situation brewing, get in contact with your local leaders, with your UniServ directors, The UniServ directors can always reach out to me whenever they want to, and we can talk through the situation. But if you see something brewing, then bring it up sooner rather than later, so we can try to get an answer for you. But just, I mean, there's so much things are going to happen the first week of school that none of us are really even thinking about right now. I mean, it's so hard to predict what will happen. So a lot of it's just a little bit wait and see.
Okay, I've got one that looks a little bit outside of just teachers or educators or teachers specifically, because I know we have a number of ESP locals, and obviously our teachers have very close relationships with our ed support folks. So a couple example questions there. What are the options for ESPs who have no, well, it says FULA, I'm not sure if that's a thing or if it meant FMLA, or no unpaid days in their contract. Similar question, will ESPs continue to get paid? I think with the implication being, can we help ensure that ESPs continue to get paid in the case of virtual starts, et cetera?
I think as long as, I mean, the FMLA requirements require you to work at least 1,250 hours during a 12-month period. So there might be certain situations where ESPs would not be covered by FMLA. As far as getting paid by your corporation if school either goes completely virtual and you're a driver or a food service person, school corporations, I think State Board of Accounts has been clear that as long as school boards approve it, that they are able to continue those people. So I think you would just have to, from an organizing standpoint, just keep pushing against the school corporation, because I think the last round, I think just about everywhere across the state continue to pay their classified employees and their certified employees. The licensed teachers, I mean, the law requires that you be paid. There's not necessarily that case, and with non-licensed, but that it is legal for them to, if board approved, to continue to pay. So I think that would probably be more of an organizing issue to rather than having the law to support that requirement.
Yeah, I think it's really worth pointing out that one of the things I know we saw over the spring throughout the state was places where teacher locals really got involved in coming alongside the support staff and fighting to make sure that those things were happening in their locals. And I'd be remiss if I didn't take the opportunity to point out that, you know, in any place where there are support staff that are not currently unionized, certainly that is something that they should bear in mind, that you know, this is an opportunity for us to organize, and that they would be in a much stronger position given the opportunity.
All right, any other thoughts on that? I'll pause for a moment.
Actually, Alex, this is Sabra. I wondered if Rick could expound a little bit on what he just said, because I would think that some of our locals who don't have that opportunity for their ESPs to be able to organize might want to know how they go about organizing or contacting ISTA to organize.
Yeah, I mean, so without going through a whole spiel, because I want to be cognizant over time, I mean, I would say right now that if you are aware that there are folks in your local that is an interest, then you should reach out to your ISTA staff. You should reach out to your UniServ director, those of us on the organizing team, and we'd be happy to talk at length about what that looks like and what the process is.
Awesome. All right, another one that's, you know, a little bit sort of beyond the scope of much of what we've addressed so far concerns AFT, and what have we done, or is there sort of an aligning with the efforts from AFT? What has that looked like?
Alex, I think on that question, we're going to refer that question back to our state officers and our management team so that they can wrap their heads around. I know that there have obviously been conversations over time between the two unions, and we'll field that question to them, and they can get back to members in due course.
That makes sense to me. Let's see. Another question. I'm seeing a few pop up in the chat as well about sort of surveys, or curious about a little bit more about what Sabra and her crew were able to accomplish in Washington Township, like what their survey looked like. One question that stood out to me is sort of, I've been having trouble finding surveys, or I'm not sure if I've been receiving communications, or I'm confused about, should I be looking out for communications from sort of central state level ISTA or from my local association? So for folks who aren't entirely sure whether they're keeping in the information loop, is there anything that the panelists can say to that regard?
So in regards to whether or not you should be looking for a survey, that would be a question for your local leadership of your local association. If your local association is interested in the questions that WTEA presented to its membership, contact your UniServ director, and they can contact me, and I have those questions that I can share out. And Sabra, the other thing that when Sabra and her team were creating the questions for their surveys and their polls, it was really led again by their adaptation and their figuring out where to go next, that keeping the pulse, knowing what their membership was already thinking, and asking questions to really gain more knowledge and more insight about what their members were thinking. And so don't be afraid to write one up and talk to your UniServ director and see what we could do to help you out with that.
To piggyback onto that, I would say that members had reached out to our team to say what they wanted. And then they would say, I wonder how many other members are feeling this way. Or I know that in my close circle of friends, all of them are feeling the same way I am. Maybe we should be checking with the larger membership. And so it doesn't have to be that the leadership of your local is the one coming up with the questions. Members might send questions that they are curious about to leadership, and leadership might decide, oh, yeah, that's a really good question we should be checking with our members on.
Yeah, and the only thing I would add to that, right, is come to your leadership with the question, how can I help?
Yeah.
Alrighty. Let me see. Got a couple more. Let's see. What are teacher rights if they have an underlying health condition and the district is not planning to reduce class sizes or keep social distance of 6 feet?
I think that would be the process that you would need to go in and get medical documentation, present it to your employer, ask for some sort of accommodation. They can't just say we're not going to be doing these things. They have to engage in the interactive process. So if there is some concern, you need to start. If you haven't already started that process, then you need to start that process right now. And if you go in, they just can't ignore your request for some sort of accommodation. They have to go through the interactive process, and it can be very useful. Again, get your UniServ director involved if needed. They can contact me if there's questions, but they can't just say we're not doing this. They have to go through the process to determine whether or not they can provide a reasonable accommodation. And a lot of it might just tell you no up front, but that's not going to be enough. They have to go through the entire process and make sure there's nothing that they can do to accommodate you.
This question is for Sabra. There was a request, Sabra, if people could access or see the survey that you sent out to your members, that would be a good jumping off point for them. I don't know if perhaps if it's available on the web, could you post that link in the chat or something?
I believe that I have shared that with my UD so that he could share it with all the other UDs, so that all they have to do is reach out to there. People can also just reach out to me and let me know like where their local is and stuff like that, so I can make sure that they get information that we used, or if they want to talk about how we did our process.
Perfect.
So I have the questions, Chad, that she used for her survey.
Okay.
And so if anybody wants that, just reach out to your UniServ director to reach out to me.
Alex, can I say one more thing on that? This is really, in my mind, what ISTA is all about. We're all about the collective action. So just because my local did something doesn't mean your local can't do it. I should be helping you, just like I'm a board member, so I should be taking input from people and taking it to the leadership of ISTA. As a local leader, the same thing. I need to take that collective voice up the chain so that everybody's being heard and we're doing those things which our membership wants. So please know that none of you are in this alone. We're all in this together. And we don't all have to have the same view, but we can decide what views we do have and collectively push those forward.
Eric, we have a couple of questions about self-monitoring in terms of teachers being required to take their own temperature prior to entering the building, signing off on those types of things. You know, I know I do not have had a fever in the last 24 hours, those types of things. Is that acceptable for a reasonable request for a school corporation to inquire of an employee?
Yeah, in normal times, I think the EEOC has said that may not be necessarily reasonable, but they've given further guidance during this time period that it would be reasonable for employers to require their employees to self-monitor, to take their temperature, to even I know, like for my kids that are going to a camp in the last week or something through the school, I mean, every day we have to go in there and say that we haven't been with anybody or close to anybody that's had COVID. We're not showing any symptoms, and then you just click a button and it sends it in every single day. So under the current circumstances, they could take your temperature when you get to work. They can do some additional requirements within limitations, but yes, that would be acceptable considering the circumstances.
Pam or Chad, are you seeing any more that are sticking out to you? I have maybe one more, but it does get a little bit redundant.
I apologize if this has been discussed. I've been trying to go through the questions, and so I haven't been my best listener today. But did we cover the topic of what a teacher or school employee would be required to do regarding cleaning where students have been, especially if it's not usually their responsibility?
We have not discussed that. There's, and again, I just look at it from potential legal argument situations. I think just general cleaning stuff that you might do on a regular basis is probably acceptable considering the circumstances. But you know, we've looked in a little bit at your actual regular teacher's contract says that you will be hired to teach in the school corporation for, you know, the following period and for the following wages and so forth. And the definition of teach is generally not going to be including having to do custodial duties and wiping down an entire room, doing those types of things. You know, where that gray area is in between about this is going way too far or this is not, you know, this is not much more than we're required to do already. It's kind of unknown, but I think it's at least if you're in a situation where you have members that have concerns for their safety and health, that they're, you know, having to do extensive cleaning of their rooms, and it puts them in jeopardy of getting something, then I think it's, again, something to share with the UniServ director. We could look at a little bit closer, but I think there is some argument as to whether or not your teaching contract actually requires you to do, you know, extensive cleaning that would be done, you know, in the evenings by custodial staff and things like that, which we also, you know, in that situation, we want to keep them, you know, we have to make sure that they're protected as well. But there's at least an argument to make that if it goes too far, it may go outside the duties required by your teacher contract.
All right, I've got another one that I could put in. However, we would need to keep the answer to about 4 minutes, just to make sure that we leave enough time. Well, unless Chad or Pam, do you have a burning one that you want to throw in there? So
Nope,
this,
go ahead.
it looks like this question, and it is similar to the ESP question, but for custodial staff who are outsourced, so they're I guess subcontracted, are there any strategies, or is that something we stay away from in regard to assisting them in maximizing their workplace rights without putting them at significant risk with regard to their employment?
I'm not sure it's so much of a legal question. I don't know if it's more of an organizing it. I'm not, Rick, I don't know if you know, if they're working for an outside employer, is it even something that ISTA would be able to organize from that standpoint if they're not employees of the actual school corporation?
Can you repeat the question, Alex? Can you say it one more time? Walk through it one more time? If they're...
Our custodial staff is outsourced through a company. They've been told they're not allowed to organize, and if they attempt to do so, will be terminated. They're largely concerned about what you would expect. Is there a way to help them?
Yes. Yes, if that is an area where the local feels is of concern, I mean, it's an issue that you would want to attempt to bring, I believe, bring the public in on, right? It becomes a question of having that conversation in an open place. I think of that similarly to the way I think of several of the questions that have come up about what do we do when our schools make social distancing impossible, right? That there are answers to that can be handled through discussion, right? That we can get fixes put in place, but it's kind of when that process breaks down, then what do we do? You know, I'm thinking about local right now that the solution to the 3 feet problem was to literally take student desks and have them face to face with one another and say, well, their heads are basically 3 feet apart. Well, so that's probably not a great solution, but also if no one ever hears about it, right, then nothing ever really gets done. So there are points at which we kind of need to bring some outside attention and focus onto some of these issues.
All right, I think I'm going to wrap us there unless anybody has 30 to 45 seconds of something they would like to say. And I'm pausing. Before I turn things over to Keith, let me just point out that in the chat box, which you can access the bottom part of your screen, there should be a button that says chat. And it does have a link there to where you can find the recorded version of this webinar or share that with other folks. So, all right, Keith, go ahead and wrap things up for us.
Well, I want to thank all of our panelists for their work today and sharing their expertise. I will remind everyone, as Eric told us, that things can change quickly. And so what may be what the standard is on Monday, it may change by Wednesday. And so you always need to make sure that you are staying with the most current and up-to-date information. And I want to applaud all of our panelists and say kudos to all of our local leaders who have been doing so much wonderful work back with their locals as we work to make for a safe opening to school. Whatever opening looks like, that we want that to be safe for all of our students and all of our staff. And thank you all. As always, if no one has said I love you today, I want you to know that I do, and I thank you for your participation today.